Hi, my name's Stuart Solwin, and I'm a criminal defense attorney here in Scottsdale. And today I'd like to talk to you about the charge of criminal speeding, also known as excessive speed in Arizona. Now, a lot of people who've been pulled over and receive a criminal speeding ticket are surprised that there are actually criminal charges in Arizona simply for speeding. A lot of states don't have similar laws to criminal speeding, regardless of how fast you're going, and in those states, you'd only receive a civil traffic ticket. That's not the case in Arizona. Under Arizona law, in certain circumstances, depending on the speed that you're going, you can be cited for a criminal violation, and if you are convicted, it will appear as part of your permanent criminal record. So how do you wind up getting a criminal speeding ticket in Arizona? Well, the law that defines criminal speeding is called ARS Section 28-701.02. And under this law, there are three different subsections, subsection A, B, and C, and on your ticket, you're likely going to see one of those subsections listed. So it might say, for example, 28-701.02B. These subsections provide different ways that the state can attempt to prosecute you for criminal speeding. Subsection A makes it a crime to exceed 30 miles per hour when approaching a school zone. Subsection B makes it a crime to go over 20 miles per hour over the posted speed limit. And subsection C makes it a crime to go faster than 85 miles per hour on any road in Arizona, regardless of the posted speed limit. Now, the most common types of criminal speeding violations that I see usually fall under subsection B or C. For example, let's say, and this is something I see commonly, you're traveling on the interstate where the posted speed limit is 75 miles per hour. And maybe you're going with the flow of traffic, which could be just 11 miles per hour over the speed limit. Usually going 11 miles per hour over the speed limit at worst would result in a civil traffic violation, just a regular speeding ticket. But if you're going over 85 miles per hour on the interstate, then that will fall under the category of criminal speeding. And the police will pull you over, and they do this all the time. They pull people over and they cite them for a criminal charge. So let's say this has happened to you. You have been cited for criminal speed. What kind of punishment are you potentially facing? Well, to understand this, it helps to have a general idea of where criminal speed falls under the categories of crimes in Arizona. There are different classifications of crimes here. The worst type are felonies, and these are things like robbery or aggravated assault. These are serious crimes punishable with long prison sentences. The good news is that criminal speed is certainly not a felony. Instead, it falls under a lower category of crime called a misdemeanor. Misdemeanors are much less severe than felonies, but they still do have the potential for fines and jail sentences. Misdemeanors are then themselves divided into three different classes: Class 1, Class 2, and Class 3 misdemeanors. And what class of misdemeanor it is determines the maximum potential fine or jail time that you could be facing. Class 1 misdemeanors are the highest level of misdemeanor crime, and this would be crimes like DUI. Class 2 misdemeanors are more middle-of-the-road offenses, and Class 3 misdemeanors are the lowest type of misdemeanor crime. Luckily, criminal speed is classified as a Class 3 misdemeanor, so it's this lowest level of misdemeanor violation. The maximum penalty that you'd be looking at for a Class 3 misdemeanor are up to 30 days of jail, fines, a year of probation, and for a criminal speeding ticket, you'd also receive 3 points against your driver's license. Now, this isn't to say that that's the punishment that you'd actually receive. These are just the maximum potential penalties available under the law. But there's no mandatory minimum punishment that a judge would have to impose if you're convicted. So you could be looking at much less punishment than the maximums. And I can tell you through my years, both as a prosecutor and as a defense attorney handling these type of violations, and I've been doing this since 2009, I've never seen anybody receive 30 days of jail for criminal speeding. But technically, it could happen because it's a Class 3 misdemeanor. Now, in fact, if somebody doesn't have any prior criminal history, though, the chances of that person going to jail for a criminal speeding ticket is going to be pretty low. So that's the good news. But unfortunately, it's not something that's always out of the question. There are some courts and some judges in Arizona that do take criminal speeding very seriously, and they might have certain policies where if a person is going over a certain speed, their presumption is that they're going to sentence that person to some jail time if they're convicted. I've had some judges in some Arizona courts that I've appeared in tell me flat out that they will often sentence people to jail if they're going over a certain number. So this is certainly something to watch out for. But regardless of what punishment you would receive if you were convicted for criminal speed, that conviction, unfortunately, will go on your permanent criminal record in Arizona. And currently, there's no expungement law here. So if you're found guilty of any type of crime, including a Class 3 misdemeanor like criminal speed, that's something that's going to stay on your record for life in Arizona unless the legislature passes a change in the law which would allow for true expungement or sealing of a person's criminal record. But currently that doesn't exist. So if a background check is conducted on you later, whether for a job or a rental application for an apartment, that criminal conviction very well could pop up for the rest of your life and be something that you have to explain. Okay, so let's say you have a ticket for criminal speed. Now, let's talk about the court process going forward and what you can expect from here on out. Well, you probably received a ticket from the police officer, and if you look near the bottom portion of that ticket, there's going to be a name of a court and a date and time that you're supposed to appear at that court for your first court hearing. This first court date is what is called an arraignment. And what happens at an arraignment is that if you don't have an attorney, that's where you go to court. You have to physically be present. So if you're out of state, you have to fly back to Arizona, and you have to physically be there and plead guilty or not guilty to the judge. The arraignment isn't the time where you'd have an opportunity to explain the situation to the judge to try to talk your way out of violations. The judge doesn't want to hear that at this hearing. The only purpose of the arraignment is for you to appear in court to prove that you will show up for your court hearings and to enter a plea of either guilty or not guilty. Now, this process is different if you have an attorney. When you hire an attorney, so let's say you hire our firm, then we'll be able to file what's called a notice of appearance in your case. And that notice of appearance is a motion that we file, and we enter a not guilty plea on your behalf. This satisfies the arraignment so that you don't have to appear personally at court to enter a plea of not guilty. We'd be able to do that for you. Then your arraignment date is going to be canceled or vacated, and the court will then set what is called a pre-trial conference date, usually set about 30 days after your arraignment. There will usually be more than one pretrial conference, too. Sometimes there'd be 2 or usually 3 pretrial conferences before a case gets set for trial. As with the arraignment, if you have an attorney, we'd be able to appear for you at most of these court dates so that you don't have to appear personally. And most clients will only need to appear for maybe one court date, or sometimes they won't have to appear physically for any court dates in a criminal speeding case. We deal with a lot of clients, for example, who live out of state, got a criminal speeding ticket here in Arizona, and they never have to come back to Arizona to handle the matter because we can take care of it for them here on their behalf. Now, these pretrial conferences that get set, they're a time where the attorney your defense attorney can discuss the case with the prosecutor and try to negotiate a favorable resolution to the criminal speeding charges. We work to negotiate a good resolution in two different ways. First, we want to gather the evidence in your case to see if we can poke holes in the state's case so that they can't prove their burden at trial. The state will provide basic disclosures as a matter of course at the first pretrial conference hearing, which will usually just consist of the police report. But if we need to, we can also file requests for additional evidence that's in the state's possession. And this can be things like the records for the speed measurement device that was used to record your speed, like if it was laser, radar, or VASCAR. We can also see whether the device was properly calibrated, and we can get the records for the officer who measured the speed to see if they were properly certified to use that device. We can also see if there's any body cam footage in this case. In Arizona, many police agencies will have their officers wear a body camera on their lapel, so we can request to see it and review it to see if their conduct is consistent with what they write in the police report and whether they violated any constitutional rights while performing the traffic stop or committed other errors, which we could later use at trial or bring to the prosecutor's attention to try to negotiate a good resolution. At the same time that we're doing that, what we also want to do is collect from you what's called mitigating evidence. That doesn't necessarily have to do directly with your guilt or innocence, but this is something that we'd be wanting to bring to the prosecutor's attention to try to negotiate the case to show you as a well-rounded person, that you're a good person and that you don't deserve to have a conviction on your permanent criminal record. Mitigating evidence can include things like the fact that you have a clean driving record, maybe, or that this is your first criminal citation. It can also include more personal things, such as what you're doing with your life outside of the case. Or, for example, are you going to school? Are you raising a family? Are you volunteering in the community? Do you have prior military service? This is all just to show the prosecutor a more rounded version of you that goes beyond the basic allegations in the police report, which is all the prosecutor is going to know about you. So we want to round that out, and we work both of these angles, the mitigation angle and the evidentiary angle, to show that the state might have a problem proving their case, and also that you don't deserve harsh punishment just because you were pulled over for a criminal speeding charge. Now, let's talk about some of the ways that these negotiations can pay off and some of the goals that our clients have when we're representing them on criminal speeding charges. Well, first, one of the primary goals that we have is to avoid any type of jail time in your case. We've already talked about how some judges and courts are inclined to sentence some jail time in extreme cases. So under any circumstances, we want to try to keep that from happening. Another goal would be to try to avoid a criminal conviction entirely. Often we're able to negotiate plea agreements where a prosecutor will agree to drop criminal charges down to civil traffic violations so that you would only have to plea to a regular civil speeding ticket. This would avoid having any type of criminal conviction go on your record, and it's usually a good outcome when you've been charged with criminal speeding. Now, if for whatever reason the prosecutor is unwilling to drop the charge from a criminal to a civil speeding ticket, there's also the option of pleading your case to the court and presenting mitigating material to the judge, because under Arizona law, the judge has the discretion to order traffic survival school for a criminal speeding charge if you haven't completed traffic survival school in the past 12 months. So even if the prosecutor is unwilling to negotiate with us, there's the possibility of the judge dropping the criminal allegations against you once we explain the circumstances and provide the judge with mitigating evidence to show the type of person that you are and that you don't deserve a criminal conviction on your record. And of course, there's always the option of taking the case to trial. There's a presumption of innocence, which means that the state has to prove the charges against you beyond a reasonable doubt. And based on the evidence we obtain, we can use that to fight the allegations against you. Although, frankly, in most criminal speeding cases, a trial usually isn't necessary. And often, the case is able to get resolved with a favorable outcome without the need for going to trial. I would say the vast majority of cases, the trial is able to be avoided and we still get a favorable outcome in the case. So if you or somebody you know has been charged with criminal speeding in Arizona and you'd like to discuss your case with an attorney and to see what can be done about these charges, please give our office a call. We offer free consultations for criminal speeding cases, and we'd be happy to talk with you about your case, the facts of your case specifically, and what we think we might be able to do to help resolve these charges against you. Thanks for watching.